Oh, do you want to set the podium?
Morning. If you're the victim of a crime with a case pending before this court, you're advised that you have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. Okay, we're ready to go on the record now in calendar number 1 and 2. This is CR 2022-001-242-001 and CR 2021-001-704-001. Matters of the State of Arizona versus Lori Vallow have appearances.
Good morning, Your Honor. Katie Staub appearing for the state.
Morning.
Good morning. Our Pamela Hicks and Robert Abernathy on behalf of Ms. Lori Vallow Daybell, who's present and in custody.
Thank you. Ma'am, tell me your full name and date of birth for the record.
Lori Daybell, 6/26/1973.
Thank you. All right, so last we were here, we were waiting on a second report from Dr. Hernandez. Since that time, Dr. Hernandez has been relieved. The court's appointed Dr. Webster. Dr. Webster has met with the defendant and submitted a report dated December 2nd, 2024. So we do have two reports. My understanding from the state is that there's some issue, though, with the redactions that were made to that report. Did you want to be heard on that, Ms. Staub?
Just briefly, I did send an email to the court and to defense counsel yesterday, just indicating upon review, the state's review of the most recent report. It seems like there were a lot of redactions made, most concerning in the opinion of the doctor. So I just wanted the court to have an opportunity to review that and assess basically whether those redactions were appropriate.
Okay. So redaction of Rule 11 reports is dictated by Rule 11.4A2. Redactions are allowed for any statements by the defendant about the charged offense or any other charged or uncharged offense or any summary of such offense. I read that to be very broad, but I don't read that to include anything outside of statements about those things. Did you wish to be heard on redactions?
No, I'm just looking, and if it's, and I did not bring my laptop, but I have my highlighted copy here, and if it says to Section 4, the opinion as to competency, I had some things that I talked to my team about whether or not they were questionable, but I don't think I redacted, but the court can correct me if I'm wrong.
The state provided the court a copy of what they've received, and it does have a redaction here under the 4th section in the clinical formation on page 5 of the report. So it's that last sentence of the first paragraph there.
Oh, I think that was just because it was relating, it wasn't necessarily a statement, but the comment was relating to Idaho.
Okay. And I recognize a lot of the statements and information within Rule 11 proceedings might be concerning. There are certainly protections by law to prevent those from coming in as evidence at trial. And so rest assured that this information is not going to, unless it falls under limited exceptions, it's not going to bleed into any trial stages of the case. But from my reading of what's been redacted, I'm not sure that it falls within that rule. So how do we want to proceed?
It's that last sentence, correct?
Last sentence of the first paragraph under clinical formation.
I'm fine with just reading it.
Okay, so we can actually print out that last page and provide it to the state with the defense's permission.
That's fine. Or should I just show it to her?
And I just want to be clear for the record. Your Honor has reviewed the other redactions and finds them appropriate. That was the clinical formulation was the most concerning part to the state, but because we usually don't see that extensive of redactions, I just wanted to be sure that, and that's fine if the court has made the evaluation that those are appropriate. I just want that to be clear on the record.
Ms. Hicks, do these other statements Are you wanting to lift redactions of these other statements as well based on what we've discussed this morning?
So section 3, the family and social information, those statements kind of deal with the arrest, when she was arrested. So, and we're being cautious in this case, given the unique circumstances of it.
How about the other statements?
Oh, sorry. The one in the history, the victimization history, we're standing by that redaction. We wouldn't, I don't know how to phrase this, but it gave us some concern that potentially could be issues in a trial. I'll just leave it at
But
that.
how is it a statement of a charged or uncharged offense under the rule?
Again, I'm pretty new to this case. I think if I'm correct as to what happened in Idaho, there may have been, plus can we maybe approach?
You may.
Yes.
Okay, so to be clear, and we're back on the record, thank you. To be clear then, in terms of what the rule permits for redaction, the court is allowing redaction, as counsel indicated, in terms of some language about an arrest and extradition, but other redactions do not appear to fit underneath Rule 11.4 and so should be lifted so the state has a chance to review that. It's just a few sentences in a brief report, and so I hope that the state can do that and we can proceed this morning to prevent any further delay. Is that something we can do?
Yes, Your Honor.
Okay.
And the state doesn't need to review all the redactions in order to stipulate. I just, for the purposes of the record and so that we have the unredacted copy, if defense counsel can get that to us as soon as possible, we can still proceed today.
All right. So with that, are the parties prepared or willing to stipulate to the two mental health expert reports?
So I just want to make sure I will provide a copy where we can leave in the redaction on page 2, take out the other redaction, send that to the state, and then move forward. Yeah.
That's correct.
Okay. And as far as stipulating a competency, just so that the record is clear, because again, we had filed to get out of here. We're here because the court placed her placed her in Rule 11 on its own motion. That's why we didn't fill out the form and have that prepared.
Right.
We do agree that there's 2 competent reports and would like to move forward, and we just as defense don't necessarily want to technically stipulate, but we will. Does that make sense?
Not really, no. Because there's really only 2 avenues here to proceed. You can contest that she's competent, and we can have an evidentiary hearing, and you can present your evidence, or the parties can stipulate to the reports which do find her competent.
Let me just say this. We are willing to stipulate. It's just we want the record to be clear that we're here on the court's motion and not a defense motion. But we are stipulating a competency so we can move forward.
Right. But nothing in filling out a stipulation form would reflect that you're here on your own motion or that you agree with being in Rule 11. So that would be how I would suggest we proceed. Is that something defense is willing to do? All right. We've got stipulation forms in front of you in that basket right there. And so you can fill that out. The state's agreeing to stipulate to the reports.
That's correct.
Okay. The court is not yet in receipt, but will be in receipt of a stipulation as to the defendant's competency based on the written reports here by Dr. McGady, dated November 7th, 2024. Dr. Webster, dated December 2nd, 2024. Stipulation having been accepted, the reports having been considered, the court finds the defendant understands the proceedings, is able to assist counsel in her defense. The court further finds the defendant competent pursuant to statute. It is ordered affirming prior release conditions, and we'll get you a new date in front of Judge Boreski so you can proceed in your case. Judge Boreski indicated he can get you in tomorrow at the earliest at 8:30 or 9 a.m. Does that work for counsel?
Yes, Your Honor.
Okay, so I'm remanding this matter to Judge Boreski's division. We'll set it as a status conference tomorrow. That's December 6th at 8:30 a.m. Anything further?
Not,
Your Honor, can we just have a moment to make sure that that works for the victims and
Oh,
next of kin?
absolutely. Yeah, thank you.
Judge, I don't know what the order is, but we're ready on Lizardo number 19 whenever you are.
Okay, not ready yet, but we'll let you know when we are.
Tomorrow will work for everyone, so thank you.
We'll set it for tomorrow's status conference with Judge Boreski, 8:30 a.m. Thank you, we're adjourned.
thank you, Judge.
Thank you, Judge.
Are you guys going to send that today?